The Voluntary Guidelines on the Responsible Governance of Tenure of Land, Fisheries and Forests provide a historic opportunity to recognize and secure tenure rights. Adopted in 2012, they are the first internationally agreed normative standard for the responsible governance of natural resources for the benefit of all, with an emphasis on vulnerable and marginalized people. Their implementation is crucial to achieving the goals of the internationally agreed 2030 Agenda for Sustainable Development and the Paris Agreement on Climate Change. This is especially urgent in the light of increasing resource conflicts.
In Indonesia, I can tell you, land conflict is increased year by year. For 2014, we record that 400 cases. 19 people died because this conflict.
Used in the context of the Philippines, we have so many laws already on land. We have laws on agrarian reform, on Indigenous Peoples, we have the fishery code. So the idea is, what value will the voluntary guidelines bring to these laws?
I think in this respect, the voluntary guidelines will assume a pivotal role in actually managing these demands in an equitable and sustainable way, because they lay out the principles that responsible land governance ought to achieve.
The voluntary guidelines are a real human rights endeavour. It's perfectly clear from the way in which they're set out and the text that they're grounded in human rights. There are specific references to increasing the equality of ownership between men and women, increasing the access to land of smallholder farmers and so on.
It's quite important that we think in terms of who is the needy ones and how they can be part of the approach.
I tell you one thing, we did it well because we had the civil society inside the room. As Ban Ki-moon said, the CFS, the Committee on Food Security, is today the most democratic instance of the United Nations system. So we really did a good job where democracy is concerned.
The VGGT are a human rights-based instrument, so I guess some general experience from implementing a human rights-based approach can apply here. And I find three things important. The first would be for the implementing organization to have a clear human rights policy in which you can embed the VGGT as a human rights reference document. And then the second would be to do trainings for colleagues in the field and at program design level. And the third would be to collect positive approaches from the field, from implementation work, and to share those.
The promotion of the voluntary guidelines in the Philippines started with a national stakeholder briefing to explain what is the voluntary guidelines to governments, civil society organizations, international organizations, academia.
We can ask to national human rights institutions, for example, they can take lead to mainstreaming these guidelines to the public and especially to the ministry.
In certain countries we are still on the negotiation process, in others we are relatively fast developing a good relationship, trustful relationship, and not only awareness creation, but really trying and doing a change in terms of attitude towards cooperation and collaboration with communities.
The national level workshops are very much about moving towards supporting implementation. In Sierra Leone, we have a very positive, very active, very dynamic national platform there, which is coordinated by 4 ministers.
In Namibia, we established very fast a multi-stakeholder forum incorporating all actors in the country, including civil society, including the research sector, including all government ministries, different ones, who have been not speaking before on the overall topic of secure tenure, for example, in community areas.
So as a result of that stakeholder briefing, participants recommended that we should pursue the promotion of the voluntary guidelines. And to aid that promotion, we commissioned 3 studies, one of which compared the different principles of the voluntary guidelines with the major laws in the Philippines to see if we are complying to the guidelines, which are present, and which are also the gaps.
In Argentina, we used the guidelines to develop a new law. This wasn't approved at the Congress, but it was already an opportunity for us to work with other peasant organizations and people related to us, and to work also with people at the Congress. And then we had the second law, for which we have been working with the Secretary of Family Agriculture. And we already had the possibility to use this law. Less than 2 months ago in Jujuy, we could stop a forced eviction using it. So it already creates a precedent for the future. And this shows that we can go from something that is supposedly voluntary, such as these guidelines, to something binding.
What we learned from the experience to challenge this situation is we bring several laws that causing the conflict to the Constitutional Court. Constitutional Court, we asked to revoke this law. Several laws we succeed to revoke that. Forestry law, plantation law, and mining law. We can do many intervention to our government.
It's a very wide text, and we need to be, I think our role as government is to try to make it simpler and easier, so the movements, the civil movements, civil society movements, they can get that as part of their narrative.
The most important thing is, of course, to raise the awareness of these rights, in this case, the rural population. Therefore, one of the most important measures is to continue doing capacity building, to continue engaging with groups of peasants, indigenous peoples, pastoralists, fisher folk, so that their members can appropriate these instruments, these tools, and claim them.
It's time to have the voluntary guidelines, to bring them to other fora, other organizations, other mechanisms, to spread the word about the existence of the voluntary guidelines.
It's a linkage debate now, which has been now since the 90s, and since the sustainable development debate, we have been talking about linking economic regimes and human rights issues. Now this comes back again with the SDGs. It's mentioned that we have to enhance policy coherence for sustainable development. What does that mean? This means that we bridge human rights questions to other questions like the environmental questions and basically the economic regimes. And if you get into these communities with your voluntary guidelines and ask them, you have to use the guidelines as a benchmark when you assess what is the impact of a trade investment agreement.
I see a lot of possibilities, for example, with the development of the indicators and the implementations of the Sustainable Development Goals, also with the linkages to the human rights mechanisms. I think there are many opportunities there with the special mandate holders, like the special rapporteur on the right to food, but also the special rapporteur on human rights defenders, the special rapporteur working on human rights and environment, and as well as the Human Rights Council itself. If the knowledge about the voluntary guidelines gets a bit out of the agricultural corner and more into the human rights corner, then the human rights-based approach will also get a stronger emphasis.
We will require a data plus approach. We need the indicators and reporting on the indicators, but we'll also need sort of societal learning process on how to implement the SDGs. And again, in that respect, the principles for participation, gender equality, and the human rights base of the voluntary guidelines are crucial to actually make these follow-up and review processes occur in a way so that we actually live up to the spirit of the 2030 Agenda, which is leaving no one behind.
The fact that we now have concrete references is a very important thing for the future, and the voluntary guidelines will inevitably be a key part of moving forward to both target and to measure progress in achieving those targets.